these were not the beneficiaries of 6/8/1990 order.
No issue.
No, I am
They
the
are saying,
beneficiary. I am the
saying that they
beneficiary.
are similarly situated to those who were regularized pursuant to that order.
Anyway, 1983 ಇಂದ ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿ?
My lord,
ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಎ ಕ್ವೆಶ್ಚನ್ ಅಲ್ವಾ?
it's certainly more than 10 years, which is the
ಹಂಗೆ ಹೇಳ್ಬಾರ್ದು. 83 ಇಂದ 10 years ಅಂತ ಹೇಳ್ಬಾರ್ದು.
42 years.
ಹಾ, ಅದನ್ನ ಹೇಳ್ಬೇಕು. ಅವರೆಲ್ಲ ಲೋವರ್ ಸೆಗ್ಮೆಂಟ್ ನಿಂದ ಬಂದವರು ಇರ್ತಾರೆ. ಡೈಲಿ ವೇಜರ್ ಬರೋದು ಅಪ್ಪರ್ ಸೆಗ್ಮೆಂಟ್ ಯಾರು ಡೈಲಿ ವೇಜರ್ ಆಗೋದೇ ಇಲ್ಲ.
my lord,
ಅವ್ರು ಏನೋ 40 ವರ್ಷ ಗಟ್ಟಲೆ ಕೆಲಸ ಮಾಡಿದವ್ರಿಗೆ ನೀವು ಉಮಾದೇವಿ ಕೇಸ್ ಹಂಗೆಲ್ಲ ಹೇಳ್ಕೊಂಡು ವಾಪಸ್ ಕಳಿಸ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಏನಿದೆ ಅದನ್ನ ಮಾಡಿ ಕೊಡ್ಬೇಕಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಡಿ ನಮ್ಮ ಪೋರ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಸ್ವಲ್ಪ ಉಳಿಸ್ಬೇಕು. ಎಸ್,
It is that, madam. Sanction post is not there ಅಂತ ಹೇಳ್ತಾರೆ. Sanction post ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಸ್ಯಾಂಕ್ಷನ್ 40 ವರ್ಷ ಗಟ್ಟಲೆ ಕೆಲಸ ಮಾಡಿ ಯಾಕೆ ಮಾಡಿಸಿರಿ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲಿದ್ರೆ?
My lords, if I may place
My
one
lord,
submission on record,
Hindu-
the similar laborers in the case of Imam Hussain and Beat Timmana, they were also given the same pensionary benefits. They were also working in the same post alongside the very same applicants. They were also given their applications, their representations were allowed. But for us, it was denied on no basis. In fact, the KCT has categorically stated that there is no reason for why they have denied these benefits to me when I'm similarly placed and similarly situated, madam.
ಫಸ್ಟ್ ಕೇಸ್ ನಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ?
42 years.
42 years. ಅದರದ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ?
My lords?
29/1983 appointment.
29/1983. Where is your objection reply statement, brother? ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಹಾಕಿದ್ದು ಗವರ್ಮೆಂಟ್
before
ಮುಂದೆ
the regular.
Case number 81, madam. 81.
81
Mm.
ಮಾತಾಡ್ಬೇಕು.
Yes, madam. Annexary. ಇಲ್ಲ, ಅದು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫೈಲ್ ಬೈ ಅವರ್.
ಅಲ್ಲಿ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರಾ?
Even.
Reply statement is not filed in that.
ನಾಟ್ ಫೈಲ್.
My lord, there is an endorsement, my lord, annexure A5, A6 and A7 rejecting the claim of the
my
A5, my lord.
Case number 63, madam. Next is C. Is the reply statement filed by the statement before the case number 63. 4, madam. Is true that several daily have been regularized under the government order dated 6.
ಅಲ್ಲಿ ಮೈಕ್ ಇಟ್ಕೋಬೇಕು, ಸ್ವಲ್ಪ ಮೈಕ್ ಇಟ್ಕೊಂಡು ಓದ್ಬೇಕು. ಮೊದಲೇ ಈ ಕೇಸ್ ಮತ್ತು ವಾಯ್ಸ್ 80
6/8/90, madam.
ಪೇಜ್ ನಂಬರ್ ಏನು?
Page number 64, madam. 63 is the annexure C. Reply statement.
ರಿಪ್ಲೈ ಹಾಕಿದಾರಲ್ಲ?
Yes, madam.
Lord, it has been rejected on two grounds, my lord. One is that they have not been appointed against sanctioned posts. The other is that, my lord, they have not continued in service without the intervention of court orders.
Because of labor court's order they continued ಅಂತ. ಅದು
Those are the two
6890
reasons which are
requirement.
given.
6890 requirement. So you have applied 6890 order.
Lord, the conditions prescribed in para 53 of Umadevi's judgment, there are 5 conditions, my lord.
Should
The-
not have, should continue without intervention of the court order.
The first condition, my lord, is whether the initial entry was irregular or illegal. And the court has, the constitution bench has categorically held that if the initial entry is illegal, then the fulfilling the other 4 conditions will be irrelevant.
Illegal,
No length of
illegal
service.
ಅಂದ್ರೆ ಏನು?
My lord, please, my lord.
But when you call it illegal?
Please, my lord, I'm grateful for that question, my lord. My lord, we have to refer to the earlier paragraphs in Umadevi's case to understand what is illegal and irregular, my lord.
Yes.
It has been clarified that when an appointment does not follow some technicality in the procedure, which does not my lord, offend Article 14 and 16 of the Constitution, which is equality of opportunity in public employment. That is, appointment should be through open competition, merit and reservation, my lord.
ಅಂದ್ರೆ ಯಾರನ್ನೂ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಲೇಬಾರ್ದು ಅಂತ.
No, there are cases when these conditions are fulfilled, my lord. If they are done through, my lord, in fact, your lordship are aware of Nihal Singh's case, my lord. In which case,
we have followed in
Indeed.
Dharwad, we have followed that.
Indeed.
We have explained the Nihal Singh also.
indeed, my lord. In that case, the Honorable Supreme Court has carved out an exception to one of the conditions for regularization. That is, they should have been appointed against a sanction. Carved out is the finding in Nihal Singh's case that initial entry is not illegal. Therefore, having continued for them for a very long period of time, the government cannot take advantage of its own wrong by saying that it did not create sanctioned vacant posts.
Correct.
In fact, the expression used is sanctioned posts will not fall from heaven.
Correct.
When you knew that the services are perennial in nature and you required their services, you should have created. So therefore, an exception is carved out. My lord, be that as it may, my lord, in this case, the initial entry itself is illegal.
ಯಾಕೆ
My lord,
if if that was so,
please.
rest of the people who gained entry, ಅವರನ್ನು ನೀವು ಇಲ್ಲಿಗಲ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿಲ್ಲ. ಪೆರಿಟಿ ಬಿಡಿ.
Please.
Purity argument is another thing. We'll treat it separately. The persons whom you have regularized,
Please.
ಅವ್ರಿಗೆ ಯಾಕೆ ಈ argument apply
My
ಮಾಡಿಲ್ಲ?
lord, that was prior to Umadevi's judgment, my lord. Those
ಇದು ಅವ್ರ ಜೊತೆನೆ ಮಾಡ್ಬಿಟ್ಟಿರಿ, ಪ್ರಶ್ನೆ ಹೇಳ್ತೀರಿ.
ಅಲ್ಲ ಇದು
Had you done this
6819 government.
with those people who all gained entry to the gate? Is it? ಅವ್ರಿಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಆ ಪ್ರಶ್ನೆಯನ್ನ ಬರ್ತದೆ. ಉಮಾದೇವಿ ಬರ್ತದೆ, ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ದೇವಿ ಬರ್ತದೆ, ದೇವ ಬರ್ತದೆ. ಅದಕ್ಕೆ ನಾವು ಕಾಯ್ಕೊಂಡು
May I just point out this one observation in
in
para 5, my lord, it is noticed.
We understand you are very
We understand.
ಅವ್ರಿಗೊಂದು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಧಾರವಾಡ ಕಾಪಿ ಕೊಡಿ.
These are persons appointed.
This ಈಗ ಲೇಟ್ ಆಗಿ ಬಂದಿರಿ, ಸ್ವಲ್ಪ ಗೊತ್ತುಬಿಡಿ. ಕಮ್ ಟು page 2.
Please.
Read page para
From the beginning, my lord.
argument.
Para 2. Learned government advocate appearing for the appellants vehemently argues that the impugned judgment is liable to be voided since direction for regularization as such cannot be granted, and added firmly in the judgment is in specifying the post in which the employee should be deemed to have worked. The rulings invoked by the learned single judge, namely Nihal Singh versus State of Punjab, is faultsome. So arguing he seeks
Sir,
allowing-
same argument is done by your counterpart at Dharwad. Okay, just
No,
400
I'm
kilometers.
saying something different, my lord. Certainly not what has been submitted here. What I'm saying is Nihal Singh is, my lord, absolutely right, my lord. There are several judgments of this courts beginning from 2012, my lord. In fact, I have taken shelter under this case when I was on the side of the private parties, my lord. In that particular case, my lord, the initial entry was in accordance with the rules. The only the thing that was irregular was that their appointment was made on contractual basis. My lord, Umadevi's case is, my lord, it may be mostly remembered for laying down the law that illegal appointments can never be regularized. It's a balanced judgment, my lord. It also lays down that if appointment is not made in accordance with the constitutional scheme, if security of tenure is not given,
Correct.
then it amounts to violation of Article 16 and 14. That is also stated, my lord. In para 6, it is stated in Umadevi's case, my lord. But the fact remains, my lord, in Nihal Singh's case, there was a categorical finding that the initial entry was not illegal. That is not the case in these cases, my lord.
ಇನ್ನೆಲ್ಲಿ illegal ಇದೆ?
My lord, they were not, my lord, it is for them to demonstrate.
ಒಬ್ರಿಗೆ illegal, ಇನ್ನೊಬ್ರಿಗೆ illegal ಆಗಲ್ವಾ?
ಅಲ್ಲ, ಅವ್ರಿಗೂ
But if the state were to be uniform, saying that all these people are jolted heads, we can agree.
my lord, in para 4,
Some are Socrates, some are jolted. On what basis?
my lord, the
Suppose-
answer to that question is in para 14 of Umadevi's case, my lord, wherein it is held that there is no equality in illegality. Otherwise, it would amount to
So
jettisoning.
where is the illegality?
My lord, the word used is it would amount to jettisoning the constitutional scheme for public employment.
Fully in agreement with what Apex Court says. Whether we agree or not, we are bound by what the Apex Court says. But question is, what will bind us? If entry were to be illegal,
Yes.
how is that you regularize the services of rest of the people who gained entry with him, with her?
My lord, that was prior to the decision in Umadevi's case, my lord.
That-
Therefore,
That's answered already. We have answered that. Kindly come to
Please.
para 4 of the judgment.
para 4.
That lawyer advocate was also equally vehement,
Please.
like you.
Having,
We appreciate that.
no,
No,
only,
we appreciate that. Well, otherwise, state will be always at the receiving end.
my
only.
lord, the
But
only,
at least
my lord, I
our
understand,
court-
my lord, I must point out, my lord. In fact, the state of Karnataka has indeed shown benevolence to contractual appointees, even in the teeth of Umadevi's judgment. When in cases where they could not be regularized, my lord, they don't fulfill the conditions laid down in March. particularly for-
Simple ಅರ್ಥ ಆಗಲ್ಲ. 43 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದವರಿಗೆ
My lord, there is-
ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲ,
there-
ನೀವು ಹಾಗಿದ್ದೀರಿ, ನೀವು
there is a
ಹೀಗಿದ್ದೀರಿ,
scheme.
ಹೊಂದಿದ್ದೀರಿ, ಹಂಗೆ ಹೇಳಿ ವಾಪಸ್ ಕಳಿಸಿದ್ರೆ here is the rule of law.
I'm just trying to point out, my lord. The state has tried to give them security of tenure by bringing the Daily Wage Employees Welfare Act of 2012, my lord.
ಅದು ರೆಗ್ಯುಲೇಷನ್ ಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್.
ರೆಗ್ಯುಲರೈಸೇಷನ್ ಯಾರಿಗಾಗಲ್ವೋ ಅವ್ರಿಗೆ ಡೈಲಿ ವೇಜ್ ಎಂಪ್ಲಾಯೀಸ್ ವೆಲ್ಫೇರ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ತಂದು they will be given minimum security of tenure until superannuation
Which is the
and
latest, Mr. Joyce. which is the
2012
latest.
legislation.
Latest judgment which apex court.
Latest statement.
Latest body. They say
Jaggos case, my lord.
cases of regularization do not fit into 2012 act at all, which it came into force in 2013-14 and one sentence ಇದೆ.
But on 1625, I have filed the latest judgment on 16/2025 along with the memo, my lord. Lordship have got Jaggo versus Union of India under.
My lord, even in that case,
Along with
Jaggos case, my lord,
1625, because Umadevi has been more often abused by the state rather than being implementing. That is the
abused,
decision
my
of
lord, may I
Supreme
just point out, abused by applying Umadevi's
Court.
judgment
NDC para 26 of.
not to regularize
The
irregular
judgment.
appointments. That is what is pointed out in Jaggos case. Irregular appointments ನೀವು ಉಮಾದೇವಿ ಕೇಸ್ ಅಪ್ಲೈ ಮಾಡಿ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ, ಅದು ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ದಾರೆ. It has only reiterated what is stated in
Filed on
para
16.
53, my lord.
Hello. ಅದು ಇನ್ನೊಂದು ಇದ್ರದ್ದು ಅದ್ರ ಮೇಲೆ ಏನಾದ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಸಪರೇಟ್? ಅದಲ್ಲ ಇದಲ್ಲ ಅದ್ರ ಡಿಸ್ಮಿಸ್ ಆಗಬೇಕು.
But the state's contention of these, my lord, just
We'll consider it. We'll also say.
one is that they are seeking parity with those who were regularized as per the order passed in the overruled judgment, my lord, pursuant to the overruled judgment.
Dismissed.
The other is that initial entry is not illegal and not irregular.
Next. Yes. Yes.
System challenge what is to the order passed by the tribunal.
Click on subscribe button and press the bell icon to get updates from Ye TV Kannada.